This is Wendy Knox Everett. She is a hacker lawyer. She really doesn't need much of an introduction because she's pretty impressive. But I do have a few announcements. If you guys could please silent your phones just so Wendy here can not get distracted and keep right on pace with her phone and or talk. Yeah, I said that.
Silencing my own phone right now.
Yeah, without further ado, here's Wendy.
All right, so you guys can hear me? I'm going to be talking about regulatory nets versus the fishing hooks of litigation, or one of my favorite topics ever, software product liability and regulations that are out there. So this is a Bruce Schneier quote. He has been talking a lot recently about maybe there should be some regulations that will make us safe and prevent things like the Mirai botnet. I think this quote is fairly naive. There are threats posed by computers. We do have regulation now, and they are not, perfect. The alternative to regulation, a lot of people say, is to have like warranties or software product liability, which we don't also have. So we have headlines like, should software companies be legally liable for software breaches, or should I be able to sue if some software that I acquire breaks? So I am a lawyer. This is not legal advice, and I am not your attorney. We are going to be talking about mostly some policy things, a little bit of some econ tools, and so forth. So who am I? I was a software developer, and then I went to George Mason Law School. I just finished up a fellowship at Zwolgen, where we did a lot of privacy and computer security law. And we're going to hop right in and look at what we have now, which is regulation in the US really is mostly along the lines of verticals. So we have things like HIPAA, that the security rule, which talks about implementing the privacy rule. We have some SEC regulations, there's FERPA. These are all pretty much across like various industries and verticals. And then we do have some liability in the US for software. It's really mostly done through contract law, and we're going to touch a little bit on the difference between contract law and product liability law. But really here is kind of a patchwork. We're going to look a little bit at the GDPR, which is a new European regulation that's going to be taking effect in May 2018, which will actually affect a lot of US companies because of its extraterritoriality. It says that any company that has data of EU citizens is subject to the GDPR. And so for some US companies, it might really be the most stringent regulations they are subject to. So liability in the US is basically a civil law concept. There's tort and there are contract liability. There are things like if you buy a hot cup of coffee and it's too hot and it spills it on you and you get $3 million from the jury, this is like a civil tort lawsuit. And tort liability is based either on negligence, wherein you behaved unreasonably, like if you cause a car accident and someone sues you, or it's based on strict liability for product liability. So I'm not going to go into this in too much detail. You can check out my B-Sides talk from last summer where I went into a whole bunch more of this. But product liability really is more liability without fault. You might have behaved entirely reasonably and a widget came off the factory line and it was defective and someone was harmed. And really developed to sort of act as a insurance function in the market. So if someone is injured by a product, we want them to be able to recover. We also want to incentivize manufacturers to take good care. So even though they don't have to have acted negligently, we want to incentivize them to like make extra sure that they're not sending defective widgets off the manufacturing line. So contract liability is a little bit different. For software, this is really what we have right now. People negotiate contracts like master service agreements and so forth, and they can build into these contracts some provisions such that if there are breaches of the contracts, then they can get damages. Regulation, on the other hand, as opposed to liability, is the imposition of rules by a government body. In the United States, usually there are agencies that promulgate these. States can also have regulations that people are subject to. So These are actually very distinct regimes. You can obviously have both. A lot of times, though, when we're talking about how should we make software safer, there can be a debate between like, oh, software product liability will fix everything, or oh, we'll just create like an agency of to govern robots, like Ryan Calo likes to talk about, and then that will take care of everything for us. So we're going to talk a little bit about like why you might want to preference one or over the other. And we're going to talk a lot about uncertainty and risk. Like pretty much this entire talk is uncertainty and risk. So I'm going to introduce you to this term ex ante versus ex post. Ex ante basically is fancy Latin lawyer term for this going in. Ex post is imposed later, another fancy Latin term. So we usually say regulations are ex ante and liability schemes are ex post. And in terms of incentivizing security, we might want to think like, should we get the software product liability? Will that make consumers safer? Or would it be better to have more stringent regulations? And we're going to talk about which one of these might be better. Very complicated. I am actually not going to give you an answer. I don't know. I'm going to talk about some things we should think about. Mostly this is me getting annoyed at people on Twitter and being like, you're not thinking about the things you should. So liability regimes, people say they're really good for innovation because if there is no harm, there is no foul. You can put something out on the market, people adopt it and they use it and it's awesome, like fabulous. But if there is a problem, it could go before a jury, and juries bring in a ton of uncertainty. We don't tend to have that many jury trials these days anymore. There's a lot more arbitration and settlements. That can still be a lot of uncertainty for a company because you don't know what the upper limit of your damages could be, and it could drive people to be a little bit more risk averse and avoid implementing something really cool because they're concerned about what could happen. There's not really, as I mentioned, software product liability in the US right now. Consumers cannot go like sue because their word processing software broke and something happened, like they didn't get some big deal or something that they wanted to. And the reason really is pure economic loss. I'm going to go point you to my talk last year. I went through all this. Basically means if you're not bleeding, the courts are going to be like, well, that's horrible for you, but like you're not physically hurt. You merely suffered money damages, and like, we're sorry, but you have no standing to bring your suit right now. When we think about regulatory regimes, a lot of times we say like, oh, well, you know what the rules are going in. So you don't have this uncertainty of like, what would a jury do? It's a lot more settled. We have much more of an idea of what could happen. And we're starting to see much more detailed security regulations. So like the New York State Department of Financial Services just passed some highly detailed regulations that cover New York State financial companies. Like you have to report to them within 72 hours if you think you might have suffered a data breach. You must use two-factor. You must have a CISO. Like they're getting much more down into the weeds than we've seen in a lot of places. So a lot of times people say, oh, these regulations are like really burdensome requirements, like a 72-hour notification in the New York DFS or GDPR. Like this is a really big thing for companies. Like they're going to have to really be on top of their incident response game, start detecting these things and so forth. And if you get more detailed regulations, they can be out of date much more quickly as technology changes. And so we have some tension there. So this is just a sampling of some of the different regulations that govern US companies. We have FTC Section 5, a lot of people say is much more like a sort of a liability scheme because they look at reasonableness and unfairness and they're sort of judging after something has happened if there's been some consumer harm. HIPAA protects health information and we're implementing the security rule and we have all these like addressable requirements and so forth. The New York State DFS ones are up here. I'll tweet out these. These are all links. You can sort of click through and read them. And so I just wanted to call out the HIPAA security rule is one that a lot of people talk about when you think about what would a cybersecurity regulation look like. And this is detailed, but it's actually kind of vague too. We're saying we want to ensure the confidentiality, integrity, and availability, but like, what's the SLA and availability? Like, is this a 5 nines availability? Like, what do we mean? We're talking about this. And there are other pieces of this that are a little bit more detailed, but there's still there's a lot of wiggle room, essentially. So the GDPR is similar. We mentioned this is going to start actually affecting US companies, and they require things like pseudonymization, encryption of personal data, the 72-hour data breach notification, ability to correct personal data. People come to you and say, okay, you have my name and address incorrect. You have to fix it. You have to tell all your business partners and so forth. This is actually a quote from Harold Feld, who's at Public Knowledge, talking about net neutrality, but I thought it kind of nicely captured the problem that happens with regulations. They're either so detailed that they're going to stifle innovation, or they are so vague that nobody knows how to comply, and so therefore we have the uncertainty problem. And hey, am I complying? Am I not? What's a regulator going to come and tell me in 3 years? Are they going to say I was unreasonable and impose a fine on me? But if it's so detailed that that question's not there, it gets out of date really quickly, and so it's kind of in some ways you lose either way. So as I said, uncertainty is really the key to a lot of this. Businesses try to reduce uncertainty because they want to sort of bound their risk. And we are really concerned about risk avoidance as something that might depress innovation. We have a really great software industry in the US. At the same time, security is kind of a dumpster fire. I love innovation. I worked as a software engineer at .com startups for a long time. I am all for it, but things like the Mirai botnet are not sustainable. You need to start figuring out how to incentivize people to not have these problems. And one thing that we also might want to think about in terms of regulations, and you can kind of see this with the GDPR, if a regulation says, oh, if you don't follow this rule, we're going to impose a $10,000 fine on you, and the company looks at it and goes, okay, well, if we avoid that rule, we might not get caught. If we get caught, it's $10,000, but we could get a $5 million profit from this. We're going to take the risk that we might not get caught, and if we get caught, we'll pay the $10,000. It's like a tax on doing this particular thing. GDPR has said that their fines go up to 4% of your, I can't remember the exact terminology, but 4% of the money that you make in a year, which is starting to get into serious money and making a lot of companies pay attention. They cap them at 20 million, which is for startups a big deal. So they're sort of aware that companies might be oh, well, whatever, if we get caught, we'll pay the fine. And so what we want to think about as we're thinking about whether we should have an ex ante or ex post sort of regime is we sort of want to balance the innovation, encourage people to go create really cool new things, go create, home robot vacuums or internet connected coffee makers and so forth, because they're kind of cool. I love that technology, but in ways that will not, create new Mirai botnets and so forth. Can we have both? So far, we're not doing a great job in having both. And what happens a lot when we want to lean on a software product to liability is you're kind of assuming that consumers are good at gauging their risk. When you go into product liability, you start talking a lot about people's risk utility curves. Tracy was asking me before, is this talk going to have Lundarts? Because Lundarts versus knives is the really good product liability thing. They're both sharp. They can both injure you. Lawn darts are no longer sold in the US because they're dangerous and they're not really useful. Knives are equally dangerous, but you can buy them because they're really incredibly useful things. And we say it's worth the risk because the utility is so high, and you sort of balance that. There are also things like consumer expectations and so forth, but a lot of this is sort of thinking about measuring that risk. So when we start thinking about the regulations, a lot of times people do the law and economics stuff, love citing the Coase theorem. It's basically a economics theorem that says that if we reduce transaction costs, it doesn't matter who has initial property rights. People will trade amongst themselves to get to the most efficient sort of assignment of rights. But Coase himself was actually not the world's biggest fan of this. People make jokes about spherical cows, about the Coase theorem is really helpful for us to start thinking about reducing transaction costs, such as trying to figure out if you are in compliance with something or not. but like the real world is not spherical cows. Like you have to recognize that this is a tool to help you think about things. Coase also was kind of a fan of regulation sometimes. There's a collective action problem in safety. Like, will everybody go out and band together and get something to happen, to improve the public safety? You have, like the tragedy of the commons problems and so forth. And Coase recognized that a lot of times government regulation can actually be a way to do that. Like we have fairly strong child safety rules that govern toys, which sometimes are silly. Like they ban like the little super strong magnet toys. You can't get real Kinder eggs in the U.S. We've decided that this is a trade-off because we put children's safety so high. So when we're talking about product liability, a lot of times we want to think about who's the least cost risk avoider. And tort law and computer hacking can actually, there can be problems here because tort law thinks a lot about proximate cause and who actually caused the problem. And we have hackers and insecure software. We say like, okay, who is really the person who created this problem? So let's say we have a software developer who, basically does a very poor job of their security. They're not doing their encryption correctly. They're using defaults. We have someone who installs the software and doesn't change a default password that's easily guessed. We have an administrator who never updates the software. A patch comes out. And then we have a computer hacker who, in terms of making these hard to prosecute, a lot of times is not in the US. So US laws can't reach them. And they go in and write a botnet that takes advantage of the default password and the software that was never updated. Like, who is at fault here? Like, who is the person who most easily could have avoided the problem? Is it the software developer for creating the problem in the first place? Is it, the company that never applied the patch? But they might have had business reasons for not applying the patch. Like, there might be incompatibility issues. They can't take the downtime. Is it the computer hacker? But in terms of thinking about US law and like who we want to incentivize, it's not really that useful for us to think about the computer hacker because it's very hard for us to like reach him and change his behavior. We can't really incentivize him as easily because he's outside the long arm of the law. But like he is really kind of, you say, like the last link in the chain. So problems. People think about botnets all the time. You think about externalities, like the person who owns the camera does not really necessarily care that there's a botnet running on it. The people who create the cameras and put them on the market do not really care that there is a botnet on there. Like none of these people are really actually incentivized to take care of the problem. Because there's not really any market pressure right now. Like we talk about consumers and their risk utility curves and their consumer expectations and so forth. The consumer wants a camera that they bring home and they plug in and they work. So they care a lot about usability. They care a lot about the camera working as a camera. They care a lot less about, is this camera, easily hackable and does it have a default password? And so when you think about why we would want a regulation or why we would want to impose some kind of software product liability, we want to think about forcing these people to internalize these externalities. And software product liability in the case of like a camera botnet is not necessarily a great fix because there's been no physical harm, and the person who is harmed, if we're looking at a non-physical harm, is not really the camera owner who would be in a good position to bring suit. It's the public at large. And that's that sort of collective action kind of problem where regulation might start making a little bit more sense. But then we get into the how do we regulate safe cameras? So what we've seen sort of happen a lot in the software industry, and I think that this is something interesting to start looking about, how can we actually address this kind of thing going forward, is there's a lot of compliance and auditing and vendor reviews and things that are starting to happen in this industry. And they are not regulations. They are not software product liability, but it is companies negotiating with each other saying, I need you to be safe and have these particular requirements. And let's talk about SLAs, let's talk about indemnification and so forth. So we see like tons of risk management frameworks out there. Like I use like NIST SP 853 all the time. CIS controls all the time. I have spreadsheets that map these to other things. And you really can start thinking this is companies trying to figure out how can we talk amongst ourselves about how to start getting a handle on this sort of risk. And a lot of times these are very closely tied to regulations. Like if we look at under HIPAA, the BAA, Business Associate Agreements, this is kind of the business has a regulatory requirement to have their business associates also comply, in the way that this gets enforced is with a contract, and the contract says, you must be secure in these ways. Actually, yeah. So it's really kind of an ex ante scheme as they go in and sort of think about this. But a lot of this contract negotiation is also, in a lot of ways, an ex post scheme. If we think about companies indemnifying each other, that's kind of an ex post scheme, because they say, if you have a data breach and if you lose my data that I have you processing, you're going to, reimburse me certain amounts, you will cover my legal costs, you will cover whatever fines and so forth that I have. And so these auditing and compliance standards are sort of, in a way, filling a gap. They are helping companies address a lot of the uncertainty that exists in this marketplace. And so if we're going to start thinking about, talking about like commercially reasonable security measures that we would want to put into regulations, there might be something here that we would want to look at. And if we want to start thinking about like, well, what would software product liability actually look at? We could go look at how companies are negotiating between themselves with the master services agreements and SLAs and so forth, and start seeing the language that they are using to bound these, because these contracts, although they do not necessarily need to live quite as long as regulations need to be on the books, because it takes us forever to change a lot of these, they are meant to be in place for a fairly long period of time, so they can be something that can help us. As you mentioned, the way that regulations are done in the US is that agencies have to be granted authority to do something by a statute passed by Congress. And then they need to go and sort of do an expert review of the area, and they write out rules. The rules get published in the Federal Register. The public has usually 30 to 90 days to comment on them. Not a lot of people comment. I wish that more software people would go in and comment on some of these. The DHS rules to talk about the threat intelligence information sharing had, I want to say there were like 70 comments, and they were almost entirely from lobbyists. There were basically no people who worked in our industry who went and commented. In a way, this is a problem because people are not aware of it, and there's, information overload is a thing. But, I really do wish that people would go and get a little bit more involved in commenting on some of these regulations and saying, like, this is going to be a problem for my small business in this particular way. And because the agencies are actually required to take that feedback into consideration, and then they get promulgated into final rules, where they will usually sit pretty much for forever, which is why they get very concerned about making these a little bit too tech specific. But again, we're into then the more specific it is, the more outdated it can get, the vaguer it is, the more concerned companies are about the uncertainty, and they have this very unbounded risk because they don't know if it applies and could end up shifting into this ex post scheme. So that is my talk. A lot of, I don't know what the answer is, but here are some tools for you to think about, sort of a framework here. So thank you very much.